Good morning, everyone, and many thanks for joining us in this webinar. My name is María López Ridruejo, and I'm a senior associate at the Competition and EU Legal team of Cuatrecasas here in Madrid. The topic of discussion today is the review of the current Vertical Block Exemption Regulation and the related guidelines that are due to expire in May next year. And our goal is to provide you with an overview of the changes that will be introduced and the far-reaching consequence that they will have for all companies doing business in Europe, and in particular for those setting up or reviewing their distribution system or entering into any kind of vertical agreements now. We have grouped the changes that we are going to discuss into three areas. First, we will talk about dual distribution and information exchanges. Then we will discuss the main changes related to e-commerce and online sales. And finally, we will also talk about online platforms and so-called parity clauses. Of course, please feel free to send your questions through the chat, and we will try to answer them at the end. To deal with these topics, I have the honor to share the floor with my colleagues from the European network. Here with me is Elsa Mandel from Gide, Ines Bodenstein from Gleiss Lutz, and Caterina Migani from Chiomenti. But before I give the floor to my colleagues, I would like to highlight a few general points about the status and objectives behind the review that, in our view, are helpful to introduce the different topics and to focus the discussion. As many of you know, the European Commission Vertical Block Exemption Regulation provides for a wide exemption of safe harbor for those vertical agreements that fulfill certain requirements. The vertical guidelines, on the other hand, explain how the Vertical Block Exemption Regulation applies and set out how the Commission will assess those arrangements that fall outside the scope of the regulation. As mentioned, the current rules are due to expire on the 31st of May next year, and they have been under review since 2018. A milestone in this process was the publication of a draft of the revised regulation and guidelines last July that already provides a clear view on the new legal framework, as we will see in a moment. Anyway, following the publication of the drafts, public consultation was launched last summer, and the European Commission is currently processing the input received from the different stakeholders. Only 2 days ago, we saw the release of a summary of the different contributions, and we saw that there were close to 160 submissions. This means that we cannot exclude that the European Commission could still make some adjustments to the drafts to reflect these comments. However, these are expected to be minor, and most of the changes that we are going to discuss today are expected to be incorporated in the final version of the rules that will enter into force in June next year. As for the objective of the review, it is important to note that the current rules that are about to expire were adopted in 2010. And since then, the market environment has changed significantly, in particular due to the growth of e-commerce and online platforms. These changes in the market dynamics have transformed the way business operates, and as a result, the main goal of the current review is to provide up-to-date guidance to stakeholders that is attuned with or to the new business environment and market realities. In addition, the review aims at readjusting the safe harbor to eliminate false positive, which are situations that currently benefit from the exemption, although it is not certain that this will be the case, and to reduce false negatives, which is the opposite situation where vertical agreements or practices are not exempted when it is clear that they should be. Finally, the proposed rules also seek to clarify and simplify those provisions that are perceived as particularly complex and difficult to implement on the basis of the experience we had during the past 10 years, as well as they seek to close the gaps in the current framework that have led to diverging interpretations at a national level by the different national competition authorities and the national courts. In a moment, we will see how this background translate into specific changes and whether the proposed new rules are considered sufficient to achieve these goals. In any event, we cannot forget that the legal framework we are discussing today is directly applicable in each of the member states and actually determines to a great extent the decisional practice of the national competition authorities. At the same time, vertical agreements are common across all sectors of the EU economy, and all this makes the revision of the Vertical Block Exemption Regulation and the vertical guidelines an important development for all companies active in Europe, regardless the sector or the jurisdiction in which they operate. In our opinion, it is therefore crucial to already consider now the changes proposed in order to maximize the opportunities that the new regime will bring, as well as to guarantee compliance once it enters into force. And with this, I give the floor to Elsa, who will start with dual distribution.
Yes, thank you very much. So I will be talking about one of the hot topic that triggered a lot of reaction from stakeholders, that is dual distribution. So as you all know, dual distribution is the situation where a supplier within a vertical relationship is also selling the products or services directly to consumers. So is acting as a competitor to its own retailers, which creates a dual distribution relationship that is both horizontal and vertical. So under the current applicable rule, the VBER states that there is a general exemption in this situation. So while normally there is no exemption, for vertical agreements that are entered into between competing companies, then when the structure is at a dual distribution agreement, so where the supplier is also manufacturing the products, but also selling the products at the retail level, then the situation is normally exempted under the current situation. The notion of dual distribution does not, however, cover the situation where the retailer is also acting as a manufacturer and selling its own private label and competing with its manufacturer at the manufacturing level too. And there is no currently any specific rule applying to the exchanges of information that can happen between the supplier and the retailer in a dual distribution situation. So now what we look at is to make sure that the information that are exchanged have a sufficient link, a sufficient nexus to the vertical relationship, that there are information that need to be exchanged in the vertical relationship, and that there are not information that should not be exchanged. There was a case before the Danish Competition Authority that concerned the Hugo Boss brand, where Hugo Boss and his retailer was sanctioned for having exchanged information on future prices, on future promotions, and these information were not considered to be necessary for their vertical relationship, and this was considered to be an anti-competitive agreement. So in the new version of the VBER, in the draft proposal, the Commission suggested two main changes. The first was an extension of the exemption to not only suppliers, but also wholesalers and importers. And the other change which triggered a lot of reactions was a limitation of the exemption by introducing a new market share threshold. So the rule proposed by the Commission is that the dual distribution, the agreement entering into the dual distribution situation can remain fully exempted only if the aggregated market share of the retailer and the supplier at the retail level is below 10%. If this aggregated market share is above 10%, while remaining under the 30% market share threshold of the VBER, then the agreement is still exempted, except for the information exchanges between the supplier and the retailer. And another limitation that was introduced, and that shows the will of the Commission to address the issue of platforms, and especially structuring platforms, is that the exemption no longer applies to what we call hybrid platforms, so platforms that offer online intermediation services, such as marketplaces, and that also sells the goods or products directly. So if you have, for instance, a platform that offers a marketplace to a producer to sell its products directly, but this platform also buys the products from the manufacturer and sells them directly, then this agreement would no longer be exempted under the new rule. So the first reason why the Commission introduced this new rule was appeared pretty late in the process, when the Commission published its staff working document. We could see that most stakeholders were satisfied with the rule, but some of them identified first an increase of dual distribution scenarios with the growth of e-commerce that helped suppliers to sell their products directly to their consumers on the internet. And this raised issues as to whether such situation could in fact be problematic under competition law. It also raised questions as to whether there was sufficient clarity on whether the information exchange were part of the vertical or the horizontal relationship. And as we'll see in more details after, some stakeholders identified maybe a risk of unfair competition from the suppliers collecting the information. So now I will give the floor to Ines to deal with the practical issues involved in this new rule.
Yes, thank you, Elsa, for presenting the legal framework that we will now see for dual distribution under the revised VBER and vertical guidelines. And we think the most prevalent situation will be that the supplier and retailer will be within this threshold of more than 10% added market share on the retail level, but below 30% added market share on the retail level. So we will be exactly in this situation that the dual distribution itself will be exempted, but not the information exchange. And in our view, this will cause many questions when practically implementing these dual distribution situations for a quite range of topics. We have listed here up to 6 topics that we wanted to raise in this context, and these are this is conduct that is really prevalent in the previous vertical and even dual distribution relationships that we have seen, but what will now need a new assessment once the VBER and the vertical guidelines come into force. And the topics that we would like to raise here is first pricing and dual distribution, but also marketing and campaigns, reporting and dual distribution, and also logistics. So for pricing in vertical relationships and also in previous dual distribution relationships, we have seen situations where we of course use recommended retail prices, where suppliers and retailers also negotiate the purchasing prices as recommended retail price minus a certain margin for the retailer. We have seen negotiations from the side of the retailer to have lower purchasing prices by saying by being transparent about its end prices in the market. is directly imported into the retailer's cashier systems per data feed. This might be necessary if you have a whole range of articles, and it would be really complex to include the pricing data yourself. So these are situations that are really prevalent in vertical relationships, and that now need to have we now need to have a new look at them and assess them under the new rules once they come into force. And I think in this context, it's important to reconsider the previous set of rules that we had, as Elsa rightly highlighted. Also previously, we had these questions in dual distribution, and our previous approach was to look at whether this information exchange that we are seeing, whether it has a vertical nexus or whether it had a horizontal nexus. And if it had a vertical nexus, whether it was necessary for the justified handling of the vertical relationship. And with these basic guidelines, I would say you could manage quite well the situations that we previously had, and you could have even managed the Hugo Boss situation, that there we had a horizontal nexus by giving information on future pricing. And this basic approach now needs to be applied as well in this situation. But once the new rules comes into force, it might be that we need additional precautionary measures on this information exchange. So we really need to see, is it a need-to-know basis? Is the data sufficiently aggregated? Does the data need to be as real-time as it is now? Or can we implement additional Chinese walls? And we think this is the structure that we now need to apply to these situations until we receive further guidance from the European Commission that has already been envisaged. The Commission has seen the problem, the issues that have come up in the consultation phase and the workshop that they had recently had on these issues in dual distribution. And Sophie Monen from the European Commission said in a recent webinar that either the European Commission will try to cover these issues in the vertical guidelines if the time allows, or they will do so in the horizontal guidelines, for which we might see a first draft in February next year. So this should give us some guidance on these issues that we are raising here, and maybe I go further down the list that we have made here. Also, the topic of dual pricing and dual distribution will be important. Maria will later explain what forms of dual pricing may now be opened up by the revision of the vertical guidelines. And here, especially, the question will come up how to implement in a dual distribution system. For dual pricing, you can have different selling prices to your retailers depending on whether they sell offline or online, if this mirrors differences in costs and investments for the specific sales channel. So as a first, you need to know these difference in costs and difference in investments. And so the question is, to what extent can you ask and have this information in a dual distribution system? Then the next topic are marketing and campaigns. To what extent can we align on timing for such campaigns? Can we give pre-information to retailers as a supplier if we are planning such a campaign, or could even use joint marketing materials, or have a forecast on expected volumes or campaign prices during such a campaign? And also here, the first assessment would be, is it a vertical nexus or is it a horizontal nexus? And what we have previously seen here, well, you can coordinate to a certain extent on the timing of campaigns, that it doesn't have too many campaigns at the same time, but you cannot align on commercial issues like planned prices, etc. Also for category management, this initiative to jointly decide how to best place the products on the shelf at the retailer, at what prices, with which marketing material. For such category management, also previously we had competitive situations in this category management. And of course, you cannot advise your competitor on the correct price to take as a category management perspective. And also here we need to reassess and have another look at how to conduct this category management under the new rules, and we hope to receive further guidance on that. Reporting is also prevalent in vertical relationships and dual relationships, that the retailers tells the supplier during yearly meetings how the turnover went for the previous year, but especially what he plans for the next years in terms of forecasts on volumes, market development, and sales measures. And this might also be some kind of automated reporting directly from the cashier systems of the retailer to the supplier. And while it's perfectly understandable that there are these reporting systems to have a better market development, we need to have a new look at this and assess whether really the level of detail is necessary, or whether this can and needs to be reduced to a need to know, to an aggregated basis under the new rules. Also, logistics is interesting in a dual distribution situation. It's quite usual that a retailer may ask the supplier to supply directly to his end customer. He will then give the name and address of his end customer to the supplier, and we have direct deliveries. And so also here, you might ask yourself, is this now an information exchange that is still admissible under the new rules, or do we have a problem here? And from our preliminary view, of course, we have a vertical nexus. It's quite understandable that these things happen, but precautionary measures might be a need to know principle. Not everybody at the supplier needs to know the customers, but only those handling logistics. And also consignment situations are now becoming complex. We see this in the fashion industry, that the retailer does not have the property of the goods, but the supplier has the property until it is sold to the end customer. And so there is a real-time exchange on these information on sales transactions, when they happen and at what prices. And of course, the supplier, if he is the owner of the goods, need to know when the transaction to the end customer happens, but does he really need to know the prices at what this happens? This is something that needs to be looked at anew. And to other topics we quickly wanted to raise as practical issues that come up for these new dual distribution systems or guidelines on them. The suppliers have complained that the market share thresholds are not fully adequate. Let's imagine a supplier that had only a very, very limited share of direct sales because he only sells directly for testing purposes or the like. And he might nevertheless easily exceed the joint market share of 10%. And so there was a suggestion that the market share should be calculated differently by taking the share of the supplier's direct sales in comparison to his entire sales. This was a suggestion, but we might say it's not so likely that this change in threshold will happen. Another thing might be more likely. Elsa has mentioned the problem of hybrid platforms, that they are not within the exemption. So hybrid platforms will have to make an individual assessment for each of their behaviors. And so the problem is, what if a supplier has a platform to sell its products, and then he opens up his platform for retailers? At once he is a hybrid platform, and he is out of the exemption from the VBER. And this was raised in the consultation period, and this seems to be kind of an unintended consequence. And so we might see a potential clarification there. So these are the practical issues that we wanted to raise, and that we need to have a close look in the further course of the legislative process. And with this, I hand back to Elsa to cover the stakeholder reactions from the public consultation.
Yeah, so just to wrap up on dual distributions, as you understand, this new rule triggered a lot of reactions from stakeholders. The Commission actually organized a specific workshop on this issue in the middle of October, and just recently published the contribution from stakeholders. And the summary thereof shows that there was a lot of reactions to dual distribution new rules, and that stakeholders were, as you understand, generally skeptical of the new rule that was introduced. The Commission especially identified maybe two positions that were a little different from retailers and suppliers. Retailers still insist on the fact that the exchange of information can trigger an abusive use from their suppliers on the way they use the information, and that was the most important issue raised. On the other hand, suppliers insist on the fact that this issue of abusive use or maybe unfair use is not an issue of vertical or horizontal relationship, but rather an issue of unfair competition maybe. And they insisted on the efficiency of dual distribution and on the beneficial effect that it has on competition. Most stakeholders all agreed that the Commission could provide more guidance on the type of information that can be exchanged or that should not be exchanged. On the other hand, as Ines just said, there was an issue identified mostly by suppliers on the market share threshold that was proposed. Some of them criticized the fact that it was maybe too low and would cover pretty much all dual distribution situations. A lot of stakeholders also underlined the fact that this threshold was too difficult to assess and would be too costly to assess, too complicated to assess, and would probably limit the case where suppliers would decide to distribute their products both directly and through retailers, which would have, of course, a negative impact on competition. So as Ines also said, they suggested other references that could be taken into account rather than aggregated market share. And another criticism that was made was also the removal of the exemption, of course, for hybrid platform, which also generates a lot of additional costs for assessing the situation and may not be sufficiently clear to understand. So we expect, we hope at least for more guidance on this issue. So in this regard, we know that the Commission understands that there may be an issue with the proposed rule. We don't know yet how it's going to react, whether it's going to change things and whether it may propose clarifications within the horizontal guidelines instead of the vertical guidelines, which are also under revision. So this we expect would be modified at least slightly in the final version of the text. So with that in mind, I will give the floor now to Caterina regarding the topic of restrictions of online sales. Thank you.
Thank you, Elsa. Good morning, everyone. I'm going to spend some words on how the draft VBER deals with the restrictions to online sales. In particular, I will talk about the restrictions to the use of marketplaces, of price comparison tools, and of advertisements on search engines. First of all, how is the situation now? Under the current VBER, online sales are protected quite a lot. In fact, online sales are considered passive sales, and for this reason, restrictions to such online sales is considered a hardcore restriction, so in violation of Article 101 and not exempted by the VBER. On the contrary, the draft VBER provides for more flexibility in relation to online sales. In fact, while a restriction to online sale is still considered a hardcore restriction, this is the case only if such a restriction has its object the prevention of distributors from effectively using the internet. So it's clear that the key issue is to understand what effectively using the internet and what a prevention to an effective use of the internet would mean in practical terms. This seems, as we will see, an easy principle, but in reality, its application is kind of difficult and problematic. Next slide, please. The most important application of this principle comes, of course, with the quite common restrictions to the use of online marketplaces, which we can find in distribution contracts. As we know, marketplaces are online platforms which connect the merchant and the customers who can buy the product directly on the marketplace. While they are, of course, a very powerful tool to reach many customers online, some suppliers many times wish to restrict the use of online marketplaces by their distributors. For example, in order to protect their brands, to avoid the risk of the selling of counterfeit products, or just in order to maintain a more direct relationship with their customers. So, as said, it is very common to find restrictions to the use of marketplaces in distribution contracts. So how does the VBER deal with this kind of bans? First of all, if we are within the safe harbor, meaning if the parties to the agreement has shares lower than 30%, marketplace bans are generally allowed, are in principle allowed under the draft VBER. This in principle is, however, a not clear concept, because in reality it seems that no particular exemption applies to the possibility to apply market bans. In fact, first of all, the VBER says that marketplace bans are in principle block exempted unless they have as their object to prevent the effective use of the internet. However, in the draft guidelines, there is no clarification at all regarding cases in which a marketplace ban could have as its object the prevention of the effective use of the internet. So this exception is very much unclear, and for this reason, further clarification has been asked by, especially by non-competition authority in the context of the public consultation. Also, it's important to note that the draft guidelines provides that also market-specific or customer-specific circumstances are irrelevant for the assessment of ERCO restriction. So it seems that in practice, no exception to the possibility to provide marketplace bans is possible in practice. So it seems that within the safe harbor, it is always possible. It will be always possible to provide for marketplace bans. The underlying reasoning of the Commission, also on the basis of the recent case law, is that marketplace bans do not prevent distributors from effectively selling online, since retailers have many other options available if they want to sell online. So, for example, first of all, setting up their own e-commerce website, or using other tools such as, for example, social networks and other channels. An important note is that this possibility to provide for marketplace bans is applicable to any kind of distribution system, so not just to selective distribution systems. Let's see what happened outside of the safe harbor instead. So if the party shares are above 30%. First of all, if we are in the context of a selective distribution system, the general rule is that marketplace bans would be allowed if the supplier who imposes the ban does not have a direct relationship with the marketplace that it wants to ban. So since the supplier cannot ensure that kind of marketplace actually meets its qualitative selection criteria, such supplier is allowed to provide for marketplace bans in its distribution contracts. Outside of a selective distribution system, there is the classical individual assessment. So an assessment of the vertical agreement on a case-by-case basis. This individual assessment, according to the draft guidelines, is based on a variety of factors, such as the degree of interbrand competition in the market, the scope of the restriction, so a total ban to marketplaces would be, of course, considered more restrictive than a ban or only to a few, just one or a few marketplaces. And most importantly, under the individual assessment, also the relative importance of the restricted online marketplace as a sales channel in the relevant market would be taken into consideration. So it seems that outside of the safe harbor, also market-specific circumstances will be taken into consideration to evaluate whether a marketplace ban is allowed or not. Next slide, thank you. But let's hold on for a moment on the provisions that I just explained, just to spot some points which remains unclear and contradictory. In fact, as we said, if we are within the safe harbor, marketplace bans are de facto always permitted, or the most of the time, irrespective of the market context. So, for example, if we are below 30%, a supplier could lawfully impose a marketplace ban also for example, to its small distributors, so to distributors who would be possibly unable to find alternative online ways to reach their customers, for example, because setting up an e-commerce website would be expensive or burdensome for them. Also, under these rules, it would be possible to impose a marketplace ban irrespective of the market characteristics. So, for example, it would be possible to ban marketplaces also in a market such as, for example, Germany, where the marketplaces are the most used online outlets. So it seems that within the safe harbor, marketplace bans would be possible, even though in practice they will reduce or impede the effective use of the internet by the distributors, in contradiction with the main principle that I explained at the beginning. On the contrary, if you are outside of the safe harbor, as said, in the context of the individual assessment, it will be possible to assess the compliance of the agreement with Article 101, also in light of the market context. So it will be possible to consider a marketplace ban as a hardcore restriction, so in violation of Article 101, if, for example, that marketplace which is object of the ban is an important marketplace in the relevant market, as the guidelines recall. So the reason of this different evaluation of marketplace in the two cases, of the marketplace bans in the two cases, remain very unclear. And in fact, it has been also the object of some comments from the stakeholders in the public consultation, especially the stakeholders from the e-commerce sector claim that at least the total marketplaces should continue to represent a hardcore restriction, or at least that every marketplace ban should be assessed individually on the basis of the characteristic of the market and of the customers, and this especially in order to protect small and medium enterprises. Quite unsurprisingly, instead, the suppliers in the public consultation welcome the new approach of the Commission towards a general permission of marketplace bans in distribution contracts. Coming to instead to the next slide, please. Let's see how the VBER deals with restriction to price comparison websites. As we know, price comparison websites are tools able to give visibility to retailers, and as they allow retailers to be found by customers. However, suppliers many times may wish to restrict the use of price comparison website by their distributors, because many times, as the word says, such websites just compare the price of the goods or services and do not provide information in relation to the quality of the goods. So many times their use is restricted by suppliers who want to protect their image and their brand. How does the VBER deal with a price comparison website and the restrictions to their use? Again, if we are within the safe harbor, so when the party shares are below 30%, in general, bans to the use of specific price comparison tools and the imposition of quality requirements to the distributor in choosing the price comparison website on which to appear are considered allowed, so are block exempted. On the contrary, wider bans, so bans to the use of the most common, of the most widely used price comparison tools could be considered a hardcore restriction if the remaining price comparison tools are de facto not capable to attract customers to the buyer's online shop. If we read this disposition, we can guess that it would be kind of difficult for a supplier to draft a contract including a ban to the use of price comparison website without the risk that a supplier would, a retailer, so a distributor would claim that because of such restriction, it is no longer able to effectively attract customers online. So there is the risk that in most of the case, a ban to price comparison website would amount to a hardcore restriction. Just a few notes on on another contradiction of the guidelines of the VBER. As said before, a distributor can be very easily denied to sell on marketplaces, especially if the agreement is within the so-called safe harbor. But on the other side, a distributor, according to the rules, should be always allowed to use price comparison website. The only thing is that in reality, the purchase happens on the marketplace and not on the price comparison website. So there is a kind of imbalance between the two provisions, the one regarding marketplaces and the one regarding price comparison websites that probably the final version of the VBER would need to solve. A few words regarding what happens instead outside of the safe harbor. So when the party shares are above 30%, in this case, it's even more difficult to defend a restriction to the use of price comparison website on an individual assessment. In fact, outside of the safe harbor, quality requirement, the request for quality requirements is not enough to block exempt a ban to price comparison website, as the Commission considers that quality requirements can be met directly on the distributor website where the purchase actually take place, and so it is not necessary to impose quality requirements on the price comparison tool. Moreover, the Commission considered that such restrictions are not justified in those cases which are, although kind of rare, where the tool provides not just for a comparison of prices, but also for reviews linked to quality factors such as customer services, delivery services, and so on. Finally, let's see in the next slide how the VBER deals with the restriction to search engine advertisement. The criteria are very similar and so very easy to be kept in mind. So very similar to the ones I already explained. First of all, bans to the use of one specific search engine would be considered allowed, as it is supposed not to prevent the effective use of the internet by a distributor. On the contrary, a ban to the use of the most popular, most widely used search engine would amount to a hardcore restriction if the remaining search engines are not capable to attract customers to the buyer's online shop. Again, it seems that especially in the case of search engine nowadays, a ban, for example, to the use of the main search engine, which is of course Google search, will always amount to a hardcore restriction, because it would be difficult to argue that a distributor could find effective alternatives on the web. So most probably contracts with including a ban to advertisements on Google search would be hard to be block exempted under the VBER. One last word regarding the form of the ban. These bans to advertisement on search engine could be a direct bans, meaning a direct, a clear ban to the use of search engines, but also most of the time they have the form of indirect bans. Typically, the indirect bans are consist of a ban to trademark bidding. So the distributor is not allowed by the supplier to use the supplier's own trademarks or brand names in order to take part to bids to gain the very first positions in search engine results. So it is important to bear in mind that also this kind of provision, so the bans to trademark bidding, would be qualified as a sort of indirect advertising restrictions, and so would be considered hardcore restrictions most of the time. And on this, I leave the floor again to Maria. Thank you.
Many thanks, Caterina. The next topics that we would like to cover are dual pricing and qualitative requirement in the context of online sales. Dual pricing is now, if you pass the slide, please. Dual pricing is now listed as a hardcore restriction, and as such, it cannot benefit from the exemption provided in the current regulation. And what is exactly dual pricing? Well, dual pricing is defined as the practice by which a supplier charges higher prices for product intended to be resold by a distributor or reseller online than for products that are intended to be resold by the same distributor or reseller offline. This includes the imposition of different prices, as well as any other measure that indirectly lead to the same result, such as rebate or discount schemes that de facto only benefit sales made offline. In fact, most of the cases dealing with dual pricing concern this type of indirect measures, and this was the case, for example, in the very recent decision by the French Competition Authority published in January this year in relation to the distribution of Lego. And this was also the case in several previous decisions by the German Competition Authority, in which rebate schemes in sectors such as sanitary products or gardening products were analyzed as indirectly amounting to dual pricing. So what is allowed under the current rules? Under the current rules, suppliers are only allowed to award customers a fixed fee to support their offline sales efforts. Implicitly, this is therefore a recognition that the cost of operating a brick-and-mortar store differs from those of a web shop, but it is of limited value as the financial support that is permitted cannot be a variable sum that increases with the turnover of the distributor, because that will be considered to indirectly amount to dual pricing, and again will be prohibited. In addition, the current vertical guidelines explicitly recognize that in a particular case, dual pricing may qualify for an individual exemption where sales online lead to substantially higher costs for the supplier than sales made offline. For example, because the supplier has to deal with more customer complaints or warranty complaints related to those sales. In practice, however, the national competition authorities have taken a very conservative approach when analyzing these possibilities in a particular case. And for example, in the cases in France and Germany that we have just mentioned, justifications related to higher costs faced by the supplier to maintain the quality and brand reputation in the online channel, or investments necessary to protect consumer health were not taken on board. In some, the consideration of dual pricing as a hardcore restriction under the current regime and the limited possibilities available for suppliers in this regard has been heavily criticized as not taking into account the economic realities of the market, and in particular the higher costs incurred by brick-and-mortar shops, as well as the free riding problem that offline resellers face. So what will be the situation under the new rules? This criticism has now been taken on board under the new rules, and dual pricing will no longer be considered a hardcore restriction. This means that suppliers will be able to set different wholesale prices for online and offline sales by the same distributor. The only limit now is that dual pricing will be exempted only insofar as it intends and relates to incentives and rewards of an appropriate level of investments and the costs incurred in the different channels. This, besides the problems it posed in the context of dual distribution that was mentioned by Ines before, also poses the question, of course, of which level of investment and cost will be considered appropriate to justify the different in prices applied to each channel. And here, suppliers will have to do a case-by-case analysis, but of course, further guidance in the final draft will be very much appreciated, in particular, taking into account that previous cases are not very helpful. Next slides, please. Now we move to the changes in relation to qualitative criteria for online sales. Another important change that will be introduced in the new legal framework concerns selected distribution systems. Suppliers operating this type of distribution scheme will no longer be required to impose on their authorized distributors criteria for online sales that are overall equivalent to those applicable to offline sales. The situation now is that under the current rules, suppliers must comply with the so-called principle of equivalence when setting out the criteria under which distributors are allowed into the selected distribution system for this system to be exempted under the current Vertical Block Exemption Regulation. This not only poses practical questions to determine in a particular case if the criteria are equivalent, but it has also been criticized for not taking into account the specific nature of the products that may justify the need to impose different conditions in a particular case. The judgment of the European Court of Justice in the well-known Coty case made already clear that this was possible in the case of luxury products, and now the new rules extend the possibility regardless of the nature of the product concerned. However, these restrictions, as all restrictions to online sales, will be extended as long as and if they do not directly or indirectly have as their object to prevent buyers or their customer from effectively using the internet for the purpose of selling their goods or services online. Finally, I have also included in the slide, as you can see, other changes that concern exclusive and selective distribution models. For example, the new rules include the possibility of appointing several exclusive distributors, as well as it is now possible to pass on restrictions on active and passive sales to customers of the distributor. These changes, although very important, are not specific to online sales. So in the interest of time, I'm going to leave it here for the moment and give the floor back to Elsa.
Yes, so the last topic that we will deal with is online platforms and parity clauses in the end. So just a quick introduction on the status of online platform under the new rules. So once again, as I said earlier, we see the intent of the Commission to try and put a framework around structuring platforms and platforms in general. And in order to do so, the Commission seems to have, in a way, artificially defined platforms, providers of intermediation services as suppliers within the definition of the VBER as opposed to buyers. So now platforms are considered to be suppliers in the vertical relationships, which creates a lot of uncertainties and issues as to the situation where a platform is actually acting in a hybrid way as a buyer of products. Or the other issue that was raised is the fact that platforms can no longer qualify as agents of suppliers because themselves are now considered to be suppliers. So this shows that the Commission is trying to create a legal framework for platforms that unfortunately would apply to all platforms, even the smaller ones, and creates a very complicated framework for undertakings to grasp. And as I said earlier, this also means that platforms would no longer be exempted in cases of dual distribution schemes. And this has, we have seen raised a lot of question in the review of the draft VBER. Now I will give the floor to Ines to deal with the issue of parity clauses.
Yes, thank you. And let me first round off the picture of the 4 changes on platforms that we see in the VBER and the vertical guidelines. And these are the parity clauses that I will come to in a second, and also the platform bans that Caterina has highlighted previously, that in light of the COTI decision, the European Commission has now seen the need for a clarification that indeed, if you're not exceeding 30% market share, you can have a ban of online marketplaces in your distribution system if, or to the extent that this does not de facto prevent the effective use of online sales. And let me add from a German perspective that this second half sentence might become very important in our jurisdiction. As you know, the German Bundeskartellamt was not quite happy with the COTI decision and tried to limit its effect, and so we would expect that the Bundeskartellamt will try to make use to say that a per se full ban of marketplaces could amount to such a de facto restriction of the effective use of online sales, depending on the importance of the respective platform in the respective market. But let me now come to the topic of parity clauses. Next slide in more detail. As you're aware, we have the wide debate on the handling of wide parity clauses and narrow parity clauses. And these clauses have now received new names, I would say rather complex names, in the revised vertical guidelines. And so the wide parity clauses that undertakings are not allowed to have their offers cheaper on other platforms as well as on their direct sales channels. So the wide parity clauses, they are now called a cross-platform retail parity. And as you're aware, the situation previously was that wide parity clauses were mainly seen as inadmissible, as leading to a quite similar price level for online sales and less competition between platforms. And they were only exempted for market shares below 30%. We have case law on Expedia, so one of the hotel booking platforms in Germany. And now the European Commission has taken up the criticism that has evolved around wide parity clauses and included wide parity clauses as excluded restriction in Article 5 of the VBER. So it's not a black clause, but a gray clause, and it will be excluded from the exemption. For all cases outside of the VBER, so exceeding 30% market share, we see for the guidelines in the vertical guidelines how to assess these wide parity clauses, the individual factors, but also the result that they are very likely to produce net anti-competitive effects, the wide parity clauses. And within this whole framework, what we are also now seeing in the draft DMA, so the legislation for the gatekeepers of our online economy, that wide parity clauses will be prohibited for gatekeepers. So the picture for wide parity clauses goes into a quite distinct direction. They are widely seen to be inadmissible, and we think it would be rather difficult to implement them within the individual assessment as given by the vertical guidelines. But for narrow parity clauses, the picture looks different. Narrow parity clauses now coming by the complex name of retail parity relating to direct sales. So it's about these clauses that undertakings that offer on a platform should not be allowed to insert their offers for lower prices in their own direct online or offline sales channels. So these narrow parity clauses. And we had a really blurred picture in Europe so far. You're aware of the diverse views on narrow parity clauses of national competition authorities allowing clauses, others like the German Bundeskartellamt prohibiting them, then coming the legislator and prohibiting other clauses in France, and then we have diverging court decisions now with the interim situation in Germany that they seem to be prohibited, at least in this specific case. And so we have very diverse views, and this may be explained also from the economist views, who say, the economists say, narrow parity clauses really have anti-competitive as well as pro-competitive effects, and what it is in the specific case needs to be assessed with a view to the individual circumstances. And so it's quite fortunate that narrow parity clauses are not included in the draft VBER as excluded restriction. So if it comes like this in the future for market shares not exceeding 30%, narrow parity clauses would be generally exempted as well. And for all cases exceeding 30% market share, we have quite detailed guidance in the vertical guidelines how to assess narrow parity clauses with a view to the specific circumstances of the market. We need to look at the market position of the platform, whether it's a mature market or whether we really have a small startup there. We need to look at the relation between direct and indirect sales. So is it really a prevalent sales channel to sell via platforms, or is it not? About the substitutability between these sales channels. And with regard to the individual exemption, free riding plays a crucial role. Do we have a problem of free riding in this market? So do consumers look on the platform but buy somewhere else? And so the platform does not receive the remuneration for its services. Is it a real problem? Is it prevalent? And so do it need to be covered? These are the individual factors that need to be looked at in each and every market. And requires an individual assessment for narrow parity clauses. But as I highlighted the DMA for the wide parity clauses, let me give you an outlook also on potential coverage of narrow parity clauses in the DMA. We have seen the recent negotiations and discussions of the European Parliament, and the European Parliament intends to have narrow parity clauses included in the DMA as well, so that they would be prohibited for gatekeepers as well. But the last word has not yet been spoken. Legislative process is ongoing, and let's see what the Council is going to do with narrow parity clauses. So to summarize, it will be also in future quite difficult to have wide parity clauses in place, but for narrow parity clauses, look into the market, look into the individual circumstances, and come to an individual assessment there. And with this, I close on parity clauses. Thank you.
Many thanks, Ines. With this, we have concluded the changes we consider more important and the topics we intended to cover today. I see that we do not have time left, and this is unfortunate as there are many questions from the audience. We will do our best to reply to them by email after the webinar. And I thank you all for being with us today, and see you next time.